This is Arkady Frekhtman. I'm a New York City personal injury trial attorney. And today we're going to be answering an interesting question, and that is, when do the New York courts allow for punitive damages? And we're going to examine a recent case from the Appellate Division, First Department. And this actually comes from an injury blog known as the New York Injury Cases blog. And it's run by an attorney by the name of John Hochfelder. And I've mentioned this attorney in other videos. He does a great job. He examines appellate division decisions. That means the appeals courts in New York. And then he writes a blog. And so I subscribed to this blog, and I thought it was interesting. So I read it, and I thought it's interesting enough to do a video about it because a lot of our viewers are asking this question: can I get punitive damages? And oftentimes, even clients of mine ask, can I receive punitive damages? Can I add a claim for punitive damages? And I'll let you know what the decision was in this case and what the facts and circumstances were in this case. And, at the end of the video, you'll know what the court considered and what the factors are. But then I'll do another video and I'll examine another case. And this one was not in New York, and that one was a settlement, and it also involved punitive damages. And that's also an interesting story. So maybe I'll touch on that other case at the end of the video and talk to you a little bit about it, but I'll do a separate video about that other case. So this case involved a gentleman, and it happened on September 27th of 2019. And him and his wife were actually residents of another state. They lived in Idaho on the West Coast. And they were on vacation in New York, and they went to Manhattan. And like a lot of people do, they got in one of those red open buses, like the double-decker open sightseeing buses. The people sell tickets for that on the street, and you pay a few bucks, out of like $50, you get in, and it takes you all around, and you could see all of Manhattan. It has different stops, downtown, midtown. So what happened was, he was on the bus and he went to the upper deck, the way a lot of people would. I would probably go to the upper deck if it was nice weather and sit out there, and you're out in the air, you're seeing everything firsthand without any barriers. So that's the way to do it. So he was up there, and he was taking, actually it was a night tour on top of the sightseeing double-decker bus on September 27th. And he was seated on the right side of the bus, and his right arm was on the railing that went around the open and uncovered portion of the upper deck. So, it wasn't like outside the bus. I mean, obviously you're not supposed to stand up, you're not supposed to put your hands outside the bus, but his hand is just on the railing where it's reasonable for a person to do that. Now, what happened was, the bus got so close that it struck a portable traffic message board that was placed there by the city of New York. And as a result of this, his hand was injured. This happened on First Avenue between 38th and 39th Street. And it's one of those boards, where they put like electronic signs, like they'll say road work ahead, or they'll write something else. So it's one of those portable signs. So his arm was badly fractured and lacerated, and he ended up suing the tour bus company, its driver, and also the city of New York. Now, during pre-trial discovery, this was in 2021, they were conducting discovery, and the plaintiff's attorneys asked for the criminal background check on the bus driver. And the results actually disclosed that before this bus driver was hired by the tour bus company, this private company that runs these double-decker buses, before that, he had various criminal convictions, including possession of a weapon, reckless endangerment, and he had many open charges, criminal charges, that were open and pending at the time, and they were about driving a vehicle, that he was driving a vehicle in a reckless way, so bad that he had criminal cases pending against him. And so, armed with this discovery, the plaintiff said, well, now I want to amend my lawsuit, amend my complaint, and I want to add a claim for punitive damages. And his argument was that the tour operator should have conducted a criminal background check of this driver, because now they knew, or they should have known, that he was not qualified to operate a tour bus when they hired him. So it's a negligent hiring negligent supervision, and also punitive damages. Now, as you may have known from past videos, punitive damages basically are also known as exemplary damages. And what that means is that the conduct was so wanton, so reckless, so egregious that it endangered the public. So now it's a different type of damages. It's in addition to everything else. So now the plaintiff could recover for pain and suffering, past and future, for his hand injury. He could recover for future medical expenses. He can recover for lost wages, whatever he can prove for himself in terms of economic as well as non-economic damages. But then there's another component that now the jury could be asked to allow for punitive damages to punish this tour bus company because the conduct was so egregious, so wanton and willful that they knew they were going to harm the general public, but they did it anyway. And it was so likely to cause harm to the general public and safety that they should pay. And that's really calculated based on their profits and how much money they make. For example, if they make a certain amount of money per day, they might say, okay, pay a day's pay over to the plaintiff, and that's going to be like punitive damages. And that's meant to deter this type of conduct, in the future, that, hey, well, if you have to pay a week's worth of profits or a year's worth of profits or even a day's, some of these companies make millions and millions every day. So a day's worth of profits, hey, maybe you're not going to do this again because we want to deter this type of behavior. So what happened in this case was actually plaintiff's motion in the Supreme Court of the state of New York in the county of New York, which is Manhattan, was granted. And remember, in New York, the Supreme Court is the trial court. So it's weird, but the Supreme Court is actually the lowest court in New York because it's the trial court. And so the defendants didn't like that decision, that it was granted, that he could amend and he could sue for all these punitive damages. So they took it to the First Department Appellate Division. And that is the court that decides all of the appeals if you don't like the ruling in the trial court where the lawsuit is. And that court is in charge of Manhattan as well as the Bronx. So this was Manhattan, so the First Department. And the appellate court said that the new allegations adequately set forth conduct that may constitute a willful and wanton disregard for the interests of others. So they said, you're fine to amend since you couldn't have known about this before, but you got this in discovery. So the amendment is fine. But they said, even though you can bring this amendment for gross negligence, the proposed allegations, so what you're alleging and what you want to allege in the amendment, do not support a punitive damages award. So even if, what you're trying to amend and all this new stuff you're trying to do would be proven, it would not rise to punitive damages. So the case right now is on the trial calendar, and there's a pending motion for summary judgment by the city because the city is arguing that the placement of a message board like that is a governmental function. And when you do a governmental function, you get discretion. And as such, basically they're immune because it's a governmental function. They're also saying that the plaintiff had to allege and prove that he was owed a special duty because it's a governmental function, and he never did that. So the city's trying to get out of the case, and that's pending. They may succeed, it's hard to say. And then the blog also had a little bit of inside information, and I thought it was interesting. What it said was that the defendants had argued that the punitive damages motion should have been denied because there are two laws in New York, and both of these laws forbid an employer from denying employment because of a prior conviction. The first law is New York Corrections Law, Article 23-A, and it basically says that you can't deny employment to somebody because of a prior conviction unless there is a direct relationship between the offense and the employment. So here, it's arguable that there was a direct relationship, right? Because you have, prior, actually no, because that was an open case for reckless driving. It wasn't a conviction yet. If it would have been a conviction for reckless driving, then you could say there's a direct relationship because obviously he's a bus driver, but that was an open charge. The other charges like possession of a weapon, those were, I guess it's arguable whether possession of a weapon, a conviction for that could have a direct relationship to driving a bus. But I guess, but remember, these are just arguments that the city made. These are not, the appellate division, in fact, did not address either of these two laws, and it didn't even comment on these arguments. So then the second law was the New York City's Fair Chance Act, and that basically says that an employer is forbidden from requesting a criminal background check from a job candidate unless and until the employer extends a conditional offer of employment. So basically, first you have to give them a job, and then if they accept and the person's going to come work for you, then you can do a background check. But you can't just start doing background checks on people who apply, and that's the Fair Chance law. I actually didn't know about either of these laws, but it's interesting that the defendants are bringing this up. But anyway, let's get into what the appellate division did and what their arguments were. So they basically said that leave to amend a pleading pursuant to CPLR 3025B should be freely granted as long as there's no surprise or prejudice resulting from the delay to the opposing party and the proposed amendment is not palpably insufficient or patently devoid of merit. And they said whether to grant or deny an amendment is in the discretion of the court. And they said here, legal sufficiency or merits of a proposed amendment to a pleading will not even be examined unless the insufficiency or lack of merit is clear and free from doubt. So they said basically we're not even going to look into whether the amendment is legally sufficient or whether it's a good amendment. If you want to amend, you can amend, right? Because he's within his statute of limitations. He's amending in 2021 for a 2019 incident. So that's 2 years. He's not beyond the statute. And, he couldn't have known this before about the criminal issues, but he got that in discovery, so he can go ahead and amend. And they said the proposed second amended complaint sets forth new allegations that in light of this bus driver's prior criminal history, this bus company knew or should have known that he was not properly qualified to operate a double-decker tour bus filled with passengers. And these new allegations adequately set forth the conduct may constitute a willful and wanton disregard for the interests of others. That's willful and wanton. So they said that the bus tour company failed to overcome the heavy presumption of validity in favor of permitting amendment. And furthermore, the bus company does not allege that it would be prejudiced by the proposed amendments. And so that was all granted, right? The amendments can go forward. However, and the whole punitive damages decision is all based on this one sentence. However, the proposed new allegations do not support a punitive damages award. And that aspect of the motion should have been denied. Period, right? They don't give you any analysis. They don't explain why, but they do cite to a case. And that case is known as Levinson versus 77 Perry. So the only way you could figure out why they're denying punitive damages is by reading this other case. So let's go to Levinson. Let's look at Levinson. I took a quick look at it. Now this Levinson case, I don't really know why they cited to this case, or maybe this wasn't the best case to cite to. They might have cited to this case because it's a relatively new case. This decision, by the way, that we were just talking about was entered on November 21st of 2023, so right before Thanksgiving, just a few months ago. And the Levinson decision was in January of 2023. But the Levinson case had nothing to do with, cars, or it wasn't even a personal injury case. What happened in that case was that the plaintiff owned a 3-unit apartment, or 3 separate apartments in defendant's building, which was a co-op building. And the plaintiff was arguing that the defendant's board of directors entered into a binding contract to sell them the area of the roof above 2 of the apartments that they owned. And that later the defendant refused to complete the sale. And they also argued in their complaint that the defendant adopted amendments to the proprietary lease and bylaws for the co-op that basically said that now these plaintiffs cannot combine the 3 units into one. And they said this, because these amendments only affected them, right? It only affected these plaintiffs, no one else, that they violated a business corporation law known as 501c. And so it was like a breach of contract case. And they said the emails were an offer and acceptance because they did have emails saying you could do this. And basically, there was a portion of the decision that dealt with punitive damages. And the court just basically said that we affirm the portion of the order denying plaintiff's motion for leave to amend the complaint to add a claim for punitive damages. The motion court denied the motion because defendant's alleged conduct was not directed at the public generally, but that requirement applies only to breach of contract claims. So basically what they're saying is this particular conduct, in not allowing them to have this roof or combine their apartment, doesn't really hurt the general public, right? It doesn't hurt everybody, it just hurts these people. And so it's not punitive. But in the other case, hiring a driver that's driving a double-decker bus and he has a criminal record and he's dangerous, and you know about this, or you could have found out about this and you hire him anyway, but he's driving a double-decker bus, so that does affect everybody, right? So I don't really see the parallels. I don't see how this is a precedent for that. But I don't know, maybe I'm missing something. Let me know what you guys think. It seems kind of silly. But let's read more of this. So what they're saying now is that plaintiffs did not seek punitive damages in connection with their breach of contract lawsuit, and plaintiff's motion was properly denied because their allegations would not support an award of punitive damages. So they're saying plaintiffs didn't seek punitive damages, right? That's not something they sued for under the breach of contract. And then the motion to amend was denied because even if all these allegations were true, the amendment was allowed, even that wouldn't support punitive damages. And then the court goes on to examine plaintiff's argument, and they say plaintiff's argument that they can recover punitive damages in connection with their statutory claim because it's analogous to a breach of fiduciary duty claim is unpersuasive. Plaintiffs did not plead a breach of fiduciary duty claim against defendant, the cooperative, and in any event, they don't owe them a breach of fiduciary duty. And then they basically say, even if a breach of fiduciary duty or tort claim were pled, defendants' alleged wrongdoing in connection with adopting new bylaws and amending proprietary leases does not meet the very high threshold of moral culpability. Now, this is in quotes, right? Quote, the very high threshold of moral culpability, end quote, necessary to award punitive damages. So, again, they're not really saying what you have to do. They're just saying it has to be a very high threshold of moral culpability, that it has to be very, very immoral. You have to be very blameworthy. You have to do something very, very bad. But they're not saying what it is. And then they finally give you a little bit of a definition. They say, okay, it doesn't meet the very high threshold of moral culpability necessary to award punitive damages, such as, quote, a wanton or reckless disregard of plaintiff's rights. So now they're saying a wanton or reckless disregard of someone's rights could lead to punitive damages, I suppose, right? Such as, and that's one of the examples of moral culpability. And then they cite other cases, and we, unless we start reading those cases, but it's like then you open up a can of worms, right? It just keep going down rabbit holes. They cite a case called Zuckerman and another one called, but we could do another video where we examine what the definition is of punitive damages and how you can actually obtain punitive damages. But here they say, accordingly, the proposed amendment was palpably insufficient or clearly devoid of merit. And so that's the decision that they base their case on. So let me know what you guys think. I mean, I think it's a little bit unfair to this man. I mean, he still can recover compensation, but I think it's a little bit unfair because I think this is an example of issue decision, right? Or as opposed to issue finding. Like in this particular context, it's more of, I think the court's role is more of a role of issue finding, just like it is on summary judgment. They could say, look, okay, it's possible this could rise to punitives, leave it up to a jury. Let's say what a jury says. Even if a jury allows for punitives, they can later say, well, you know what, it's not legally sufficient. But what they did here is they wouldn't even let you bring the claim, even though you're within your statute of limitations, even though you have evidence, hey, this guy's a criminal and he's a convicted criminal, and they hired him anyway and they let him drive a double-decker bus and he got too close to this sign and injured someone. Now, I guess maybe what they're thinking is, what's the connection between the criminal convictions? It was for possession of weapons. How does that relate to driving too close to a sign and hurting someone's hand? Maybe that's too tenuous. But the point is that the court is, resolving issues by themselves, and, at least they should let the plaintiff do discovery, like depose this driver, get all the criminal evidence. And then once discovery is complete, once the case is on the trial calendar, maybe they could decide the punitive damages issue on a motion for summary judgment with expert affidavits or whatever, what have you. But what they're doing is they're not even letting you bring the claim. Basically, they're saying you can't even bring the lawsuit because the lawsuit is timely, right? It's within the statute of limitations, but they're saying you can't amend because this does not qualify as punitive damages. And the only rationale is that one sentence reference to this co-op decision, which I don't even understand what that has to do with the price of tea in China. But let us know what you think. Okay, I hope this was helpful. And as promised, we're going to do another video on a recent settlement where the plaintiff also amended to include punitive damages. And that is a very interesting case. It wasn't in New York, but it was by very good lawyers who I know. And they just did a webinar yesterday where they went over it. And it was a multi-million-dollar settlement for a child that was seriously injured. And I thought it was a really interesting case. And it really teaches you how to work up punitives, but also it teaches you how to build the case and how to settle a case properly using some of the methods that I've talked about in prior videos, where you give the defendants an opportunity to settle, and if they don't settle, then the numbers might actually go up, and you really put the defendants in a corner and make them pay fair value. And if they don't pay, you have to be ready for trial, which is what these guys did. And they kept the pressure, they kept the foot on the gas and the pedal to the metal, and they really got a top settlement. It's a very interesting case. So I'll do a video about that a little bit later, hopefully by next week. Okay, everyone, thank you. Please like and subscribe to our channel. Let us know what questions you have. We are here for you, and all the best. Okay, bye-bye.